My name is Bob Kaufmann. I am a psychologist from the San Francisco Bay Area, working in a couple of counties there, and a lot of my work is in forensics, and most of that in family law, custody evaluations, mediation, and consultation to attorneys. And I also conduct other forensic evaluations in criminal and civil matters, and am affiliated with a trial and jury consulting firm in San Francisco. And to my right.
Hi, I'm Margaret Lee. I'm also from the San Francisco Bay Area. My kind of entire practice at this point is in the area of family law. I do child custody evaluation, child custody mediation, and do a lot of consulting to attorneys, do some hybrid work with attorneys, and do review of other custody evaluators. I testify quite a bit in court. And I think one thing that informs the way I look at this area that we'll be talking about today is my training was as a child psychologist. I did a lot of therapy with kids for many years, and my interest in getting in this area of family law was to continue to help children in a different way by helping set up their environments so that it would promote their development and growth.
I'm David Martindale. I am from Florida these days, and all of my work is consulting.
The idea was that more and more of this review work product review, consultation was evolving. There was a relatively small body of literature on it, and we thought that it would be good to try to understand it and get some different points of view. We saw that there really were some very different points of view about how to approach consulting work and work product review. So how do we apply ethical principles of psychology, ethical principles of forensic psychology, and child custody to consulting work? And I think we'd all agree that there should be a place for ethics, and it's really about discussing what that place is. So yeah, we can go to the first slide.
I'd just like to also add that another piece of our discussion, which will be woven in, are issues that aren't strictly ethical issues, but are kind of practice issues in terms of when you're practicing in this arena, what are some of the dilemmas you run into, and what are some of the consequences of whatever actions you decide to take in a particular case.
Most of us in the field start out in neutral kinds of roles. Many of us starting out as child therapists, as Margaret did and I did, or testing kids for learning disorders, etc. And even in our work in family law, we typically start off in neutral roles, either as mediators, mediation training, or as court-appointed evaluators. So the role of work product review and critiquing other people's evaluations really creates a significant shift, and we want to try to address the issues of once you shift onto working with one side of a case, what are the challenges and how do you address maintaining a role that preserves integrity, maximizes credibility, because at the end of the day, if you testify in court, your credibility is, if not everything, pretty close.
Essentially what I do is for starters, use entirely separate contracts based upon what I'm doing. And my work always begins with a contract that I call a statement of understanding for work product review. And it is very clear in that contract that the only activity covered by that contract is the work product review. And essentially, the terms of that contract are that I will review all the available documents. At the conclusion of that process, I will orally impart my feedback to the attorney. And the reason that I stress orally imparting information is that I don't feel it is fair to engage in activities that may be useless to the person who's paying my fees. And there are at least times, though I have to admit they are in the minority, when I tell attorneys that which they don't wish to hear. And they would not have wanted a report from me. So it seems silly for me to prepare a written report. I give them the information orally, and then if what I'm telling them is what they were hoping to hear, then I let them know that there's now another decision to be made. And the decision is they can either use me to provide litigation support services, which usually emphasizes the development of questions, either questions for the direct examination of favorable witnesses or cross-examination questions for unfavorable witnesses. Sometimes it involves other activities. Or they can designate me as a testimonial expert. And I let them know that it has to be one or the other. I will not do both. And the two things that Robert mentioned that I will go back to are the issue of maximizing credibility. And without launching into a big discourse on it, I believe that by using this procedure that I maximize my credibility, that it's obvious to any judge that I'm a retained expert. That kind of chips away at your credibility a little bit, and that's something that's unavoidable. But I think that by keeping these roles separate, I hope to maximize credibility. The reason that I avoid contact with the litigants is that I don't want to formulate opinions in a subjective manner. To whatever degree that can be avoided, I want to look at the same stuff that the evaluator looked at. If there were things made available to the evaluator that the evaluator elected not to even look at, I will not form any opinions, but I may comment on what might have occurred if the evaluator had looked at these documents, what light might have been shed on certain issues in dispute. And with regard to dilemmas, the only significant dilemma that I encounter using this process is that every once in a while, particularly with wealthy clients who are unfortunately used to having what they want in life, they get bent out of shape when they hear that I'm not willing to meet with them. And their attitude sometimes is, hey, I'm paying this guy, I want to spend some time schmoozing with this guy. And I don't want to hear their perspective. I think it increases the probability that then what I come up with is tinged by subjectivity. So that's my procedure in a nutshell.
Just briefly, I think in terms of work product review, when I go into it, what I like to do first and foremost is to get only a child custody report with virtually no input from the attorney. In other words, I like to look at it as cleanly as possible, and my contract with attorneys is less discreet than Dr. Martindale's. I leave open any number of possibilities, but there is an understanding when I have an initial call with an attorney that there'll be some decisions to be made, and some of the decisions could have impact on things like discoverability. So, in other words, if you, obviously I'm sure everybody understands that if you have discussions with the attorneys and take notes, et cetera, you eventually testify. Everything that you've written down and discussed is discoverable if you go on the witness stand. But I would just say initially, I like to look at custody reports just as an isolated, discrete entity to sort of get an opinion without any extracurricular input from people, so that I can talk about what the report is like, whether there are perceptions or a sense of bias or one-sidedness comes through, whether it is even-handed, whether it's addressed the issues adequately, methodology, etc. I'm not going to go into the details of what might happen after that, but I would say that it is very, very rare that I meet with clients in the context of work product review, but I think we'll be getting into some discussions also about other areas such as, do you participate in strategy for trial and preparing questions for testimony. But I
just want to say one thing. Bob made reference to the initial telephone call with the attorney, and if I can put in just a brief plug for rigidity, because I think it's a wonderful thing sometimes. I will not even have an initial discussion with an attorney. I try and deal wherever possible with secretaries, and I try and explain that I do not want to hear your take on the case. I want to look at the materials, and I want to develop my own take on the case. And then once I'm done, then we can have our discussion. And the reason that I give them relates to the fact that Bob alluded to, the discoverability of stuff if you become a testimonial expert. And at least in the state of Florida, there is a very clear statute that relates to note-taking. I'm in violation of the law in Florida if I don't take notes during these kinds of conversations. And therefore, those notes are discoverable. So if I were to have an introductory discussion with an attorney and I took notes and those notes became discoverable, a good cross-examining attorney could very easily suggest that my initial impressions of the case, the issues in the case, and so on, came to me through the conversation with the attorney as opposed to being developed independently by me.
I think the combination of both the task force that was put together with the goal of creating guidelines for those doing review work after the review of a child custody evaluation. That was our goal. We worked for a year. I think David and I were put on this in some ways to have different points of view and to have those points of view represented. And it went along with also the special issue, and out of the task force and out of the special issue of the JCC, what I came to see was there is tremendous disagreements among people. If you read this issue, you have all the way from hybrid models that I propose to very discrete models. And in the task force, what we came to realize is that we haven't had sufficient discussions of all of these. And people were holding points of view. I think over the time of the task force, though, we all started to be able to really listen to each other and identify that there are certain areas where we have legitimate disagreements that we need to have these discussions, and we need to have them not into a we need this guideline or that guideline. It's like, what does this really mean? What is really ethics? What is really not a problem? I think there are two main areas that have fascinated me. One of the areas that came up a lot was the idea of multiple roles. If you review a report and then are going to testify on it, but then you help develop cross-examination questions, are those two different roles in an ethics sense that it would be a problem to your neutrality, objectivity, or you would potentially harm somebody? Are those two roles, or are those two different functions that you perform in a case? Now, clearly, as David mentioned before, if you review, you meet with the attorney, and God forbid, we'll talk about this later, you may meet even with a parent, and then you get on the stand. One might. Some others might not. And one might only under certain conditions. You know going on the stand that you're going to be asked. Your notes are available. You talk, when the attorney says, I want you to testify, you go, well, this is what I'll have to testify about, what do you think? So you may not appear as neutral. You may need to explain how different actions affected you. But there is a legitimate debate going on, you'll see it in some of the articles, about are these multiple roles that would be unethical by APA standards, or are they different services or functions? And if they are, do they require a much more diligent inspection of every action you take to be sure that your neutrality and your objectivity are not being compromised? That was one big area. The second big area that I found very interesting is the whole idea, and it's in the ethics, I don't have the one written down, but about given what different data pools you have, what in fact can you testify to? What level of opinion can you make? I think almost everyone agrees that unless you have done a direct evaluation, you cannot make kind of ultimate opinions about what should happen to this kid or anything like that. Although, through hypotheticals, you can come darn close. But I think it's very legitimate, so if you're reviewing just the evaluation in the testing, the evaluation in all the file, maybe new information that the evaluator didn't have, also an issue of debate, that you need to vary what kind of opinions you can legitimately make. And so I think that was another area where there's a lot of discussion and debate at this point.
Yeah, I'm assuming that very few people in this room have the ethics code memorized, but you should note that what Margaret put up on, these are Margaret's slides, what Margaret put up with regard to bases for assessment was 9.01c. And the importance of that, as I see it, is that that is the issue about which there is dispute. 901A and 901B both cover this general principle that we don't make statements about people we've never laid eyes on. That's my translation of it. But 901C carves out an exception about which there is tremendous controversy, and I will just say I would love it if APA would clarify 9.01c before somebody's case becomes a case before the Ethics Committee. The problem with 901c is that it alludes to the issue of, well, what if you're doing what I'm calling a work product review? Is this then an exception to 901A and 901B? My position on it is that the reason that sections A and B are still applicable is that when you do a work product review, as I conceptualize the task, the only thing you can formulate an opinion upon is the work, not the people described in the work. So that when I testify, I make it clear to the person who's going to be paying the bill that the only things I am able to comment on are things relating to the manner in which the work was done, the methodology employed. I will not go near the issue of, well, but did the evaluator get it right or get it wrong? I may formulate an opinion that the evaluator got it wrong, but I view that as a personal opinion, a subjective opinion, not one that I'm comfortable sharing with the court.
Okay. I'd just like to add one thing, is there are a couple of guidelines in the AFCC guidelines for child custody that relate to when you're not in the custody evaluator role, and I would just like to say I disagree with them entirely. And those include to not be in any multiple roles and to never meet with a parent. Child custody evaluation?
Yes, we're inviting questions along the way, so.
Even though I'm not under oath, I'm assuming that what you are anticipating from me is an honest answer. And with that in mind, I will point out that there was a political process involved in the development of the revisions to the specialty guidelines that did not contaminate the first document. When the first document was put together, nobody really gave a damn about whether or not it secured APA approval. And it was not, APA approval was not sought, as far as I know. When the second document was being prepared, and by the way, for those of you who are not familiar with this, the second document was approved in August or September of 2011. As far, I'm sorry. The document, by the way, that is now referred to as the Specialty Guidelines for Forensic Psychology. The first document was the Specialty Guidelines for Forensic Psychologists. And what happened when plans were made for the revision was it was, I won't say known from the start, but certainly a potential goal was that it would be prepared in such a way that it would be more acceptable to APA. And there are different pressure groups within APA, and I think that caused some of the wording to be more delicate as opposed to forceful, provide a little bit more wiggle room, and so on. And as you may have deduced, since you probably all have remarkable clinical skills, I'm really not a fan of wiggle room. I really like things to be nailed down as clearly as possible. But one of the things I do like about the new document, by the way, is I like the title better. Because the title essentially suggests that what this document refers to is guidance that you ought to be following if you are doing this stuff, whether you call yourself a forensic psychologist or not.
Okay. Okay. We're gonna move on. We're gonna move on. Go for it.
No, go ahead.
It's a question of whether it's admissible. I mean, I'm assuming I'm the naive one, and it's just an assumption. I testify all the time. I am admitted. I'm seen as an expert. I do a little bit different in terms of what I might be willing to say on the stand than you, but I think that it's routine, and that's why we're all doing it, is because we are asked to. At times the court feels it's helpful, and I think that there's both the issue of that we are certainly expert in terms of being able to critique another psychologist's work in order.
Marvin, I think I can give you one simple example. Obviously, this, we could have a more prolonged discussion, but in part because Jay was one of the people who chimed in response to what you said. I'll point out that one of the things that people, particularly people like Jay, who really place a lot of emphasis on testing and making sure that testing is done right, there are times, believe it or not, when psychologists use tests in ways that are directly contradicted by directions in the manuals for those tests. So when I talk about offering testimony about someone else's methodology, I can certainly point to a specific thing in a manual that says you should do this or you shouldn't do that, and point to things that the evaluator has done. And to me, that's a simple process, and it's just a very short, simple example of the kind of thing that a reviewer can do without ever having met any of the human beings who were involved in the evaluation. And I think I better stop at that.
Yeah.
Yes, we can. Why don't you? I have something else to say, but I'm going to hold it for the moment. So as part of our title for this workshop, it has to do with joining a team. And it's really trying to discuss what are the implications for joining a team. And I guess I'm on the wrong page of my little notes here, but once you get involved in review work, you're dealing with other people and other people's expectations. So clearly, you're retained by an attorney and you're joining the quote-unquote team, and we need to discuss what it means to be on a team. But there are clear expectations from that attorney, and we also have the client or parent who is, number one, funding directly or indirectly the consulting work, and you can even have other consultants already engaged on the team, and you could even have a team of attorneys who are working on a particular on the particular case. So we also have, apart from the team, we have what we call other interested parties. So we still, even doing consulting or review, work product review work, we still are operating within the domain of the judge or the trier of fact, and one could certainly make an argument that while you're retained on one side, your responsibility still is to assist the court or the trier of fact in decision making. And other interested parties, of course, are the parents and children, and keeping in mind the best interests of the children standard, which I think gets us into a fair amount of debate about that. So I think we can go on to the next slide. So some of the dilemmas or the issues that we run into are, what are the definitions or what's the consultant's understanding of the quote-unquote goals of the team? And the goals of the team may not be our own goals. We, of course, would like to say that we are dedicated to truth, justice, and the American way, all along in ethics, but to the extent that our goals may or may not match the goals of the team, or particular people on the team, can create conflict and it can create some specific pressures. I think David alluded or spoke to that to some degree directly about delivering the quote-unquote bad news to the attorney, but I think we would all agree that we would not be doing our job if we omitted delivering the quote-unquote bad news, which meant what they did not want to hear. But I think that really comes in the context of us doing an honest and straightforward work product review, which is to talk about the strengths and the weaknesses of the evaluation and how the evaluation did or did not meet standards of practice in our field. I don't know if either of you want to chime in any more on that.
No, I just want to chime in on one quick thing, since you made reference to the best interest standard. And I'll go back again to Marvin's criticism. In some states, and I'll focus temporarily on New Jersey, there are very specific factors that the law says you're supposed to be attentive to. So let's say, for example, that an evaluator in New Jersey states clearly that he is not going to be attentive to one of those 14 factors because in order to do so, it would give one of the litigants an unfair advantage. If I'm doing a work product review, I can comment on the appropriateness or inappropriateness of deciding, as a psychologist, that you will ignore one of the 14 factors that the law says you're supposed to be paying attention to. And again, I can do that without laying eyes on any of the people involved in the case.
I think we're going to be talking a little bit more about best interest later on this afternoon. I just wanted to say one thing, because I think that when we think about what is the goal of an attorney, it is usually to win their case. And during much of the conference, you hear about that it is the ethical task of an attorney to be a zealous advocate. I would just like to make a comment that sometimes, and with some attorneys who I prefer to work with, attorneys they state explicitly in their contracts with the parent client that they will only work within what they understand to be the best interests of children. they are not just interested in winning the big case the best way, winner take all, that they hold in mind and in their work with the parent the best interests of children. Also, I would like to note that the AAML, which is the American Association of Matrimonial Lawyers and represents some of the really top family law attorneys in the country, changed their guidelines. And they changed their guidelines from needing to be a zealous advocate, and they changed it because they recognized that this could be quite hurtful to children. This zealous advocacy stuff, which makes it more adversarial and then more polarized with more conflict, and we all know conflict hurts children. And they changed it to say the effective advocacy considering the client's best interest, including the well-being of the children, family peace, and economic stability.
I would only add, and go ahead, Jay.
Well, I was going to say, when you're on one side of the case, it's really not possible for you
I'll stand up here so we have...
Nancy wants to make sure that you are on tape.
Thank you. What I was going to say is, it's theoretically not possible for somebody to work on one side of a case to know what's in the best interest of the child if you don't have all the information in front of you, you only have the information provided by one side, and you've never even met the child. So
We're going to talk about this a little bit later.
well, when you talked about, it's the American Academy of Matrimonial Attorney, not the association, but when you talk about that's what their goal is, I don't know how they can state that as a goal when it would not be humanly possible to achieve that goal.
Well, I would disagree somewhat, but I did say that it is within how they understand the best interests of the children. I'm going to stand up here just because I like standing better, and we only have 2 mics. And you can run around. Sounds good.
I was only going to add about the goals of the attorney. They can be, there's kind of the broad goal of winning, but what winning means can be pretty different for different people, because sometimes attorneys will echo either what parents want specifically in terms of specific parenting plans or specific rulings around legal custody, or attorneys' views of what it means to quote-unquote win a case and what a favorable outcome is, which is maybe a little bit different from talking about just winning. A favorable outcome can come in several different flavors and styles, but it adds more pressure, I think. It's more input onto the consultant that one has to be cognizant of when the attorney really has a specific idea of where he or she wants the outcome of the case to be.
Next slide.
Sure. I think the second bullet point here, David is certainly the most clear on that in terms of what he will or won't do, and states that at the onset of a review process. I think probably Margaret and I are less sure about that, and I never know what's needed and what's going to be asked of me and when I do an initial review. It's just that there are implications for going one way or the other, and again, it's our responsibility to inform people about that. I think some of the real issues can come up if you start working under a certain assumption about what the task is, say perhaps to be an educational witness or something like that, and either something arises in the case and the attorney feels that they really need you to do something else, or some other consultant comes in and they really need you to start working on cross-examination of somebody else. Those, part of this is the tension that can arise when there is pressure coming from the team approach to do things that you may think either are not ethically sound, not methodologically sound, or you just don't want to do them. I think we can all agree that, I guess we've sort of morphed into this, but really reviewers' ethical duties are pretty clear, which I think are to be even-handed and to be objective, to be accurate in what we say to the best of our ability. And I think there are some who have been writing about this say that we need to at least keep in mind what the best interest standards are, at least in our understanding or review of work product. I would only add that it's true that there's no scientific methodology for conducting work product review, but there is plenty of research and there's plenty of accepted methodology on conducting custody evaluations. And so it seems to me that part of the task here is to give opinions. Just a second, Marvin. Give our opinions about how evaluations and work product conform with accepted standards in our field. And I think you'd like to disagree at this point, so that's fine.
The single best article that I've ever read in the business of being a family law expert is authored by David Martindale. It's in the Journal of Psychiatry and Law, and it's called Cross-Examining Mental Health Experts in Child Custody Litigation. See, I have the title memorized. Okay, it's about 20 pages long, maybe 18, extremely detailed on how to cross-examine experts in mental health custody evaluations. I'm wondering if it would be possible to actually develop a work product instrument, review instrument, in which then we can start to put some methodology into this process, and it's not just a selective review of a work product, but actually develop a tool. Actually, using your article basis.
I'll get to work on that, Marvin.
Did you want to?
I have some comments at the end of this slide.
Yeah, because I'm going to turn it over to you in a second anyways.
Have you finished the slide? What do you want to say?
No, I think the last set of bullet points there is, we're kind of conceptualizing. Part of this is how do you remain an autonomous being while being part of a team? And that, I think, is part of the challenge working in this field when there are strong personality and strong needs. There's a question in the back.
Nancy, we have
I'd like for each of you to give a yes or no to this. Does being on the team imply that you are now a hired gun?
I'll handle that first.
He's our hired gun to address that question.
I don't have the name of the article memorized, even though it's one of mine, but I did address in an article that I wrote this whole issue of the term hired gun. And what I pointed out is that we really need to make a distinction between ethical hired guns and unethical hired guns, but we're all hired guns. I don't do this free. I'm being paid. I understand the expectations of the person who pays me. However, the reason that I'm comfortable, at least, with my ethical behavior in this regard is that I make it clear to the person who is about to pay me what they get and what they don't get for their money. And among other things, I make it clear that they don't get to tell me what they need me to say on the stand. And when they start going that route, I pull out, and I have done that. I've made it very clear. I'm going to offer testimony that I think will be helpful to the trier of fact. You presumably are paying me because it's your belief that when I do that, it will advance your position before the court. However, it might not. And one of the reasons it might not is that neither you nor I know what I will be asked on cross-examination. And when cross-examination comes, I respect the oath that I took. And when I start giving honest answers to questions posed by a cross-examining attorney, some of what I say may turn out not to be helpful to your case. If you accept my terms, then we can work together. But I'm still a hired gun.
So I guess the answer to your question is that third from the bottom bullet point, right? We're sticking to our guns, so we must be hired guns since we appear to have them. And I certainly would agree with what David said. The notion of hired guns is a perception of what we do. And sure, some people we know or hear about in the community have what we call the predictable review process, which is it's going to conform to whatever somebody wants of them. But at the end of the day, quote unquote, I think that people who err so much on one side, they lose their credibility. And I think that even as a testifying expert, when you can acknowledge things that counter your opinions, you gain some credibility. But like David, I think our service to attorneys is to offer them clear and honest consultation and opinion from our point of view about strengths and weaknesses. And it's interesting, in some of the jury research that I have participated in for about 12 years, when we do mock trials, in civil cases, and it could be patent cases or intellectual property or various kinds of things, and we have the attorneys present literally either opening argument or presentation of evidence on both sides. It is a bear to get those attorneys, because you're working with one side, to construct the best possible argument and case from the other side. And I think that it really is something that we can bring to the party, so to speak, to really help attorneys know the best case from the other side that they're dealing with.
I'll answer that question. I read your article about the ethical and unethical hired guns. I like that. But I think the reality is, as I read an evaluation, I give my opinion. The attorney says, well, this part's going to help my case, this part isn't. And I say, but this is what you're going to get as testimony. And they will decide whether on the overall it's going to be okay or not for their case. They make that decision. I then review more material. I inform the attorney again of what my opinion is, whether it's changed or not. And at some point, when they have to disclose me, they'll decide if I'm going to be helpful. I think we may seem like we're hired guns in part because we only end up testifying in those cases where our opinion is in fact helpful to the case. And the other cases, they say, bye, have a good time. It's very lovely talking to you, Dr. Lee. I learned so much from you. So thoughtful. So, I think that in that way, and I would agree with what Bob said, is if you don't conduct yourself that way, especially if you're in a small community, you aren't going to be getting this kind of work because the judges just will not find you helpful. And that's another kind of concept I think is useful, that we need to be helpful to the court regardless of our role and task. Do you want me to go on? Mm-hmm. I wanted to just... I think that there's some pitfalls when you become a team player, and I'd just like to mention a few that I have seen people engage in, although I didn't measure it with a legitimate, empirically researched instrument. It's just my opinion.
So you can't say that the research shows?
No, and I can't even say that the trends in the research show. It suggests. Oh, exactly. Okay, I think that when you get on a team, people can get lost, and I want to win. They can get lost if there are other experts on other sides. That ugly kind of competitive nature many of us have can rear up, and we have to be careful about that. And we might be more competitive and therefore take a stronger position. that we can get sucked in very easily. Attorneys, I've had any number of cases where the attorney said, oh, the whole case rests on you, and you're so wonderful, I'm sure it's, that kind of pressure. It's like, but they flatter us, basically, and so you have to kind of be careful of that. Also, I think most of us are aware that by the time we get into court, people have invested a lot of money in us. And that, again, is a pressure to, I've got to do a really good job. And I think if you aren't very diligent, you can move into that hired gun position and kind of forget to testify to some of the things that don't go with the case so well. I also think it's important for us not to lose sight of the fact that and this is what I see as making family law different than every other kind of law, is, after a criminal trial, someone goes to jail or doesn't. After, a civil trial, there's awards or there isn't. After these trials, this kid is going to have to go back and have a relationship with both parents. The parents are going to have some kind of relationship, no matter how tenuous it may be after a custody trial. And that's the reality. That's the environment we work in. But I think we can do a lot in terms of, do we stir it up? Do we make it more adversarial? Do we become polarized in ways that then are a mirror for the parents, that's how you solve problems? You get really polarized and adversarial. So from my perspective, it's important to keep in mind that children exist in this arena in ways that they don't in other arenas. Are we on to the next? Oh, okay. So I'm going to be kind of the moderator here. I'll put out a little something and you all can respond. Okay, do you ever meet with a parent? This is a big debate. And I also do a lot of work where I'm not working from a custody evaluation because the county I work in won't order them. So we don't have that nice big piece of information. So I will often meet with a parent. I will sometimes do that when I'm reviewing an evaluation, and not usually, but on occasion. On occasion, to understand what objections they had to the evaluation, what information was not considered. If it's not in there, it's hard for me to know that it was not considered. And also sometimes to get specific information about issues that the evaluator raised and particularly were highlighted. So let me give you an example of this. I reviewed a report where the evaluator 13 times in a 30-page evaluation made note of the fact that the father had the mother pick up children from school on his custody days. 13 times. This was a major piece of evidence for this evaluator. And it was never explained, but the implication was very heavy that he doesn't make himself available to his kids. In talking to this dad, apparently what it was is he was the sole person bringing in money for the family. He worked. He was perfectly happy to put his kids in after-school care and then come and pick them up. But Mom said, won't you let me pick them up? And I can pick them up any day. You can't come get them, and I can do their homework. And he goes, okay, great. I'll text you and let you know what time I'm going to be there. And she said, great, just text me anytime, by noon. So there are all these texts saying, I can't come pick up my kids, and it's noon, and it's for 3 o'clock. And the evaluator assumed that at the last minute he kept asking his ex-wife to pick up the kids and therefore was not a responsible and involved parent. He was never asked about how this system got set up. That was very useful information.
Can I check?
Yeah.
Let me start with the point of agreement. I agree completely with Margaret that what she has outlined is important information. Where I think she and I disagree is that I don't think you need to meet with the parent in order to get that information. What I do is I give parents written homework to do for me. And I ask them questions like, are there items of information that you put before the evaluator that in your view were not utilized? Are there items of information that appear to have been utilized but that in your view were not assigned sufficient weight? Are there parenting attributes that you attribute to yourself that you feel were not weighted strongly? Are there parenting weaknesses that you feel were weighted strongly, and so on? I go down a whole list of things, the ultimate goal of which is to basically ask the parent, when push comes to shove, what really are the sources of your dissatisfaction with the opinions expressed by the evaluator? Let's kind of go through it notch by notch. And the final question in my standard homework assignment is, what is your perception of the gap between what the evaluator has recommended and what you see as the best parenting plan for the child? Because sometimes this actually precipitates settlement. Because sometimes when parents are forced by me to look at it in this systematic way, and when they get down to the bottom line of how different really is what I want from what the evaluator has recommended, there are times, believe it or not, when they pack it in. And they basically say, you know, the difference isn't that great. Maybe it's not worth all this litigation.
So, David, so what's the difference between doing that and meeting with the parent?
Oh, the difference, yeah, thank you. The difference is that it's all a matter of record. It's all in writing, and it's discoverable. So that when I'm being cross-examined, the cross-examining attorney has what I consider to be the appropriate opportunity to examine how I reached my opinions.
So how is that different from meeting with the parent, where ostensibly you would be taking notes contemporaneously that would be then discoverable, and if the attorney on the other side were shrewd enough, they would ask for all of your notes and then cross-examine you on the notes?
Part of the answer, seriously, is that I can't possibly take notes that well. I mean, I think that what a person gives me in writing is much better. It also gives the person a chance to really think it out more clearly. But the other part of this is that I am very struck in my work by what I just call the likability factor, because I don't know what else to call it. And in the same way that I am critical of evaluators sometimes because I feel they've been sucked in by the likability factor, they've simply found one of these parents more likable, and a parent who is more likable to another adult is not necessarily the better parent. I believe that I am susceptible to the same pressure, and that if I meet with people, I may find them likable or not likable, and so now we're into subjectivity. Whereas if they simply give me a document, I think it's easier for me to look at it with somewhat better objectivity. But I'm always acknowledging that there are certain forms of subjectivity that can't be avoided, like the pull of money.
Are you only giving this questionnaire to the parent who's employing you, or both parents?
Yes, clearly one of the disadvantages, if we want to label it that way, of this kind of work is that you only have access to the perspective of the client, of the attorney who's retaining you.
I mean, I think, yes, go ahead.
Could you offer it to the other side? Could you not, sir?
Martindale, could you not offer that to the other side as an effort to try to collect it from the other side?
I think within the context of an adversarial system, I don't think that's likely to happen. But it goes to the other side in the course of discovery. So the other side then does get a chance to pose cross-examination questions to me based upon that information.
I suspect that the attorney you're working for is not really going to welcome that kind of approach to get that information from, you know, the other client. My experience, I think, you know, it is this issue that Margaret brings up about what don't we know, what is not in the file, what has not happened that could be material, essentially, material information. I've had that mostly very often come through attorneys, and I've had sometimes with attorneys who say that their client has, believes that there are factual errors in the report, have them go through the report in detail with their client to find out, A, what the factual errors are and whether the information that the client is saying was not included was actually presented to the evaluator. I think that's one of the keys, and then sometimes those issues can come in almost as hypotheticals on direct exam.
I'd just like to make a comment, is what about the likability of the attorney? Couldn't that impact and couldn't that be subjective? And couldn't that mean
Yes.
that then we might kind of see it in a different way? I just think I trust myself more interviewing a person for an hour and not being completely wowed by them, or hate them for that matter.
I'll simply say that my whole goal is on minimizing bias. I never, ever lose sight of the fact that all of us are susceptible to bias. And it's simply a question of what are the ways in which we can minimize the effects of bias, and that's really what my procedures are aimed at.
Can we move on and then maybe come back to Jay? Because we only have 17 minutes or something. Okay. We're not going to get through this.
And we didn't make that many slides to begin with.
We only have 13 slides. One of the big kind of debates is and most people I think first review some material, say the evaluation, the underlying data, and then becomes the issue of how can or can you not help the attorneys, knowing that whatever help you do is discoverable, and it may give certain appearances. You may not appear as neutral. You may not appear as objective. That is a legal question that the lawyer gets to decide. Do they want to do that? And you get to decide too, if you don't want to be kind of look terribly in court. Now, I'm going to just say my thoughts on this, and then you guys can say your thoughts. So I pretty much always get involved with my own direct examination. Most of the time I don't write a report. I do long outlines of what I know and what I can testify to. And usually the attorneys will use that. I figure in this, my job is I want that attorney to be able to get me to be able to tell my full opinion. And that's their job. I don't see that as complicating things in any way. I also will often be involved in the cross-examination or the deposition questioning of evaluators, because again, I'm trying to see everything they know, what their thinking is. I've reviewed all their work. Sometimes I'll have extensive testing questions that I will want to get clarified, like why did you put a texture response right there? Don't you know that Exner requires this, that, the other? And again, I'm trying to get information. I can do it indirectly and sometimes do it indirectly through the attorney, but I would like to hear why people think that would be a problem. And I think it's, now that we're having more and more cases, is my impression, of different experts. People are an expert and then they listen in on that testimony and then they do a rebuttal. So should we be involved in those things? Some people argue yes. Bill Austin argues yes in his article in our book. I think you would probably argue no, and I think that's what I'd like to hear from you. And that's a little different than case strategy in my mind.
Some of you attended my presentation the other day, the Institute. And one of the things I spoke about was something I call cognitive encapsulation, thinking inside the box. And in the context in which I presented it the other day, I was talking about the problems that relate to the fact that almost all of us were trained as treatment providers. And we have to at times bust out of the box that is created by that training in order to do forensic work. In this context, I will say that what many of us need to look at is things like research in social psychology, and in particular, the work of Leon Festinger. Festinger, with his concept of cognitive dissonance, would point out that you can't be on a team, a functional member of the team, unless you share the team's goals. The team's goal is to win. Once you get caught up in this concept of, I need to help the team win, you have to, in order to be comfortable with what you're doing, develop the belief that what the team wants is the right thing, in this case, the right thing for the child. So then you're caught up in a mindset that I believe really chips away at your ability to maintain objectivity.
On that last point, I might say something a little bit different in terms of looking more closely at what the notion of winning is. Because if you do work product review, you might be able to alter the notion for an attorney of what winning actually is. I mean, if you look at an evaluation and look at the underlying data and compare the notes to what's reported in the report, et cetera, you might come up with a different notion of what has been adequately, reasonably supported in the report. And it might not be what the attorney wants and thinks winning is, but you may come up with something that is more reasonably attainable in court by virtue of your opinion about what is supported in the data. And so you can actually alter the concept of winning for an attorney, and I think that's not a bad thing.
We have about 10 minutes, so I'm going to switch up the outline a little bit. I'm going to leave for last best interests of the children. And one of the things that got me very interested in doing this presentation, although it's not the main thrust, I'd like to bring up, because it's again kind of with the issue of multiple roles, but this is in terms also of the small communities that we function in and our behaviors. Excuse me. So I'm in a small community. I know all the top custody evaluators. I know a lot of the national review experts that come through also. Who can we review? Who can't we review? Who can we be in court with? What things get stirred up? When is that a dual role that is a problem? When is our objectivity interfered with? And so there's that piece, which I'll make a couple of comments about. The other piece is, what do we do in court? And what does that do to our profession, our relationships with our colleagues? What does it do to our image in court? I think if we stay professional, not personal, I think there's a meta message when we start hurling ethics complaints at each other in court, where we are mirroring for the parents and the courts the kind of adversarial conflict that is detrimental. I think that we can have reasonable debates as professionals, looking at data, discussing through testimony how to think about a situation, how to think about a family. I don't just look at whether the report's okay. I feel I am in a position to alert the judge to helpful information that is in the record. So one of the things that I have started to look at, since I keep coming up against, on the same side, in opposition to different other professionals, is what does truly interfere with my objectivity? When do I really lose it? And I'm in 2 study groups with some of the top evaluators in Marin County. I've been in these groups for 30 years. I can't review their work. I wouldn't be able to see the bad stuff in it. I mean, I just won't do it. Likewise, there are some people I dislike so much and feel their work is so pathetic that I'm not likely to be able to review it very objectively. Sometimes I know way too much about a person's life. That might influence how I see it. I would see those things as true dual roles that do, in fact, interfere with my objectivity. It can extend out, too. It's not just like if someone hurt your feelings and tore you apart, that you might want to tear them apart, or felt you couldn't because you might want to tear them apart, and that would interfere with your objectivity. The same holds for friends. So if someone tore apart my friend, that might affect my objectivity. So I really want to really look at that. Yeah, really busy.
Give him the microphone. You've got to get that on the microphone.
I also think we have to discuss what do we need to disclose. What do we need to disclose about our relationships with the other people we're in court with or reviewing? I don't have an answer on this, but I think it's a question that we need to discuss. Even I turn away a lot of cases. I won't review Nancy. I won't review Ginger. I won't review Bob. I'd probably review you, but you don't do them anymore. But, you know, because of the work we do, sometimes we end up on opposite sides. We've both been working on a case, and all of a sudden it's time to disclose witnesses, and we're going to be witnesses. And it's, to me, that's when particularly you have to be honest, and sometimes if you're up against a friend in court, you might be more honest. It might look less ugly. But maybe that is also a kind of stance we should take, that we want to be helpful to the court, we want to be professional. If we aren't, I think our profession, we will become useless. The courts will not want to hear it. I already know some judges who don't want to hear it. They just think it's this stuff for rich people to have a whole bunch of experts slinging around mud at each other.
This is a slightly different topic, but I think I wanted to introduce this in terms of the relationships and kind of a broader view of our profession before we had to stop, and I'll happy to let you chime in. I think one of the other things that we talked about is in doing review work, sometimes you're asked to do review work of people who are not as experienced as you are and who may be at an earlier point in their career, and they're doing the best they can. And what does that mean? I mean, I know I have had the experience of being instructed to copy my file and send it off to somebody to review, that on a good day I'll say, well, if he or she has a better idea, bless them. On a bad day I'll think, oh no, I don't know how I'm going to get through this. But is the same level of scrutiny, you know, I mean, it's really a question. Do we put the same level of scrutiny and level of critique on people who've been doing this for 20, 25 years as somebody who's been doing it for 5 years, you know, maybe under some mentorship, and is doing reasonably well, and maybe they're not doing everything in a totally comprehensive way, but it sort of acknowledges it's not even the authority. It can be the perception of power that one has as a reviewing expert on somebody else. And I just raised that as something we discussed in terms of how you handle doing critique work when we have a shortage of people in our field and want it to be constructive, and we don't want them to stop. We want them to learn more and keep going.
I would like all of you to give me some points here for incredible self-restraint in not going after Robert's neck. Because what he has done, in my view, is commit the ultimate sin of totally losing focus. The focus is on fairness to the child, not fairness to the parents, not fairness to the evaluator, not fairness to people like me. Fairness to the child. Fairness to the child requires that you point out errors that you feel have been made in an evaluator's work, and that you don't ease up a little bit if you realize, well, but this is a new person. I mean, I don't want to be nasty and come down hard on a new person. You can't operate that way. You can have that feeling, but when it comes down to doing your job, if the person has made errors, you have to point out those errors the same way you would point them out if they had been made by someone who'd been doing this work for 20 years.
I'd like to add the concept of the good enough evaluation, like the good enough mother.
With the intactness of my neck being vulnerable here, I don't want to imply compromising ethics. I'm just saying that when you critique, it's really easy to find fault, and you really have to look at the level of criticism. And I think actually the same thing could be said reviewing a very experienced evaluator. To go overboard to find and nitpick about absolutely everything, et cetera, is not necessarily helpful. But anyway, I'm going to stop.
Let me just quickly say that's a different issue, and I agree completely. Because if we look at the if we look at the overall goal, which is to help the trier of fact, you are not helping the trier of fact if you make mountains out of molehills. You are not helping the trier of fact if you present a small error as though it were a big error. And if I am asked, even by a cross-examining attorney, about my own views of my own work, I will acknowledge that if I were to look back on any of the reports that I did in 16 years of doing evaluations, I'm sure I would find things that I wish I had done differently. I'm sure I would find things that I would say, oh, that was a mistake. So I don't expect to find reports that are mistake-free. And when I talk to an attorney about here's what I can do and here's what I can't do, I make it very clear that I don't believe there is such a thing out there as the world's first perfect report. I'm only comfortable testifying if I feel the errors that were made were significant ones that might really affect the overall quality of the guidance that the court is going to be getting from the report.
Okay, I think we're good now.
I'd like to add one little something, and that is, as routinely after a case, if I feel another evaluator has really had a problem, done something wrong, has an area that they don't know enough about, needs more training on the Rorschach if they're going to use it, any of those things, I will ask permission from the attorney to give feedback to and if there's, I think, any ethical problems, I'll ask permission to give feedback to the evaluators, because I want us to get better at what we're doing, not just blow them out of the water.